Okay, so I thought I'd jump in on the back of Dan's Prince Harry video. That's the one where a particular lobby group were trying to obtain all the documents about Prince Harry's visa application for when he moved to the United States, on the ground that, bearing in mind the revelations in his book Spare, where he admitted to certain illicit activities, which would normally be a prohibition and stop you entering the US, was he honest on his forms? But that application has been refused. Now, I must confess, I wasn't very surprised by that, and I'll explain why shortly. But it gives me an opportunity to talk about sort of privacy law generally. I'll be coming from a sort of UK perspective, or England and Wales perspective, but it is very similar in the US. And also it allows me to just ramble a little bit about some sort of like history of privacy in the US, because it is actually quite interesting. So what's the general rule? The general rule with privacy is, it's always been considered to be quite an old right. A lot of the time it's not set down anywhere because it's, it just seems obvious. People are allowed to be themselves and are allowed to have secrets and keep information private. But when can you lose that? There are certain circumstances, but the starting position is that you may have a legitimate expectation of privacy and that is protected. Now that could be just something like, I don't say common law right, because it's not, there is case law on this, but like I say, it's always been there. You can also have contractual rights, like non-disclosure agreements, which can be freestanding, or you might often have them as part of your employment contract. You cannot discuss anything that you learn at work. I mean, that started out with, there was a common law rule to protect, quote, trade secrets. And now, that expands to everything. It's not just how you make things, it's stuff like your customer database. So you can sign an NDA, but we've also seen the use of NDAs to cover up sort of, misdoings. And they're just contracts. An NDA is, because, the agreement bit, it's like in exchange for a sum of money, you will agree not to talk about the following subjects. But you can go behind those. It is permissible to breach a privacy agreement, whether that's at common law or contractual. Say, for instance, to correct a misunderstanding, or if somebody's putting a false impression out there. So you agree to an NDA, but then your employer or the person you gave the NDA to starts saying things that are just demonstrably untrue, and they're putting out a false impression. You are allowed to actually say, well, no, that's not the case, because there is no confidence in iniquity, as the saying goes. But what about generally? What about with celebrities? Are celebrities treated any different? No, they're not. The mere fact that you live your life in the public does not dilute your privacy rights. And the courts are quite clear that it's up to you, whether you're just a private individual or a celebrity, that you can control what information goes out into the public. So the mere fact you've put some of your life out there on display doesn't mean you lose privacy entirely. And the key case over here involves Naomi Campbell. Naomi Campbell was filmed coming out of a, I don't know if the algorithm will allow this, I'll say medicine rehabilitation clinic. And she sued, and she said, I don't want people knowing this. This is very personal, this is medical treatment. I am struggling and I'm trying to get help here, and you're not really helping by splashing it over on the paper, all the newspapers. Now, the newspaper's counter-argument was, well, she couldn't have a legitimate expectation of privacy because, we filmed her in the street. But the courts weren't really having any of that, because, you could film somebody coming out of the clap clinic, and that would obviously be, a breach of privacy. But they said, well, in that case, there is a public interest, because Naomi Campbell has explicitly said that she doesn't do this. She's denied this all the time. So she's a hypocrite because she's been telling lies. But again, the counter-argument was, look, like it or not, I am a role model. And I don't want to be going out there going, yeah, of course I do this, like everybody in the industry does, because what sort of message does that send to aspiring young models? And you can be a role model, whether you like it or not. This has cropped up in a lot of football cases where people have, do you remember when we used to call it, there was like the alphabet soup of super injunctions. It was all X, Y, Z and ABC, and people were trying to cover up sort of, illicit affairs and things like that. I've got to stop saying things like that. People try to cover up illicit affairs. But the court said, like it or not, you are a role model and you are actually held to a higher standard. Like I say, it didn't water down the privacy aspects, but it did say your behaviour is a legitimate matter of public concern. But Naomi Campbell was successful in that. Similarly, where people have, say, invited people, Hello Magazine to their wedding to take all sorts of wedding snaps, but then you get lots of stories about what's going on, in the privacy of their home. They've said the mere fact, you invite to the wedding doesn't mean you can sort of like sneak in there and take pictures of what they get up to on their honeymoon. I mean, because people are using like long lens photography. And the argument there was, if you're on a sort of private beach on Mustique and you're deliberately hiding away from people, well, yeah, you do have a legitimate expectation of privacy because that's, you've gone to all that trouble to ensure that. So long lens photography tends to be sort of very frowned upon in the courts. But what about privacy in the US? Well, it's interesting because when they were drafting the Constitution and the Bill of Rights, there was a debate at the time as to whether they needed an explicit amendment, because the first 10 amendments to the Constitution, I don't know why they call them amendments because they were written at the same time, but they cover, they're the Bill of Rights, sort of Article 1, your sort of freedom of expression, your free speech rights, separation, you've got all the separation of church and state, all that sort of thing. Although that's not in the Constitution, that's in a letter, and I'll come back to that in a minute because it's sort of relevant. But you've got the Second Amendment, your right to bear arms. You've got your Fourth Amendment, your right to privacy in your personal papers. And they said, well, if we've explicitly said that, does that imply that that's your only privacy right? And it was actually Jefferson who said, in a letter, said, well, no, we don't need to explicitly put a privacy right in there because, that's just part of life, liberty and the pursuit of happiness. It's part of liberty is that, your secrets are there. We've only put that in specifically just to stop government overreach. Then you get to very interesting things about originalism, as we call it, in Constitution versus the mischief rule. Do you interpret the Constitution as the founding fathers would have done it? In other words, you can have a musket, but you can't have an AR-15, and then say, well, it protects your papers, but it doesn't protect your emails or your WhatsApp messages. And these are all the sorts of issues that the Supreme Court wrestles with. But interestingly, Roe and Wade, the abortion case, that was actually held up on privacy grounds. They didn't say you necessarily had a right to that procedure, but what they said is you have a right to privacy as to whether you've undergone that procedure. And it is fair to say that at the time a lot of people on both sides were rather unhappy with the ratio, as we call it, of that case, that it was all based on privacy, because they said, well, it's not really, is it? We're happy with the result, or some people are unhappy with the result, but they said, no, it should be arguably founded on, it's part of liberty. Bodily autonomy is part of liberty, lawful search and seizures, habeas corpus and all that sort of thing. I can do what I want with my own body. But that's where it was, and it's interesting that when it was sort of overruled and booted back to the states, it wasn't they did it on the basis that, well, look, it was always a bit of a nebulous thing anyway, so we'll boot it back to the states and let them decide how to deal with it. So yeah, that's your general thing. So with regards to the Prince Harry thing, he has a legitimate expectation of privacy in your visa documents, because normally they're not public. So a third party asking for them, well, his rights are protected by the government, and we have what we call horizontal effect and vertical effect when it comes to rights. Vertical effect is that normally, it's like with the ECHR, that stops the government or state bodies interfering with your rights. It doesn't necessarily stop private parties. So say, for instance, the government in the US, they can't infringe your freedom of speech, but a private company can. If I'm operating, a bulletin board or an internet site, I can squash your comments. Because, it's like, well, no, it's a private thing. The government can't censor you, but I can. Although you do get into interesting things where it's almost like quasi-governmental stuff. So there have been cases in the States about whether politicians can block people on Twitter. Because it's like, no, you are fulfilling a public function, and that by you blocking people you disagree with, you're interfering with their sort of First Amendment rights, because you have to be open to a higher level of scrutiny. It's very similar like with the defamation stuff over there, where if you're a public figure, people have to prove malice. You've got a lot less protection in defamation over there. Whereas over here, we don't treat private figures and public figures any differently when it comes to defamation. But in this particular case, it was like a horizontal effect. The government were protecting Harry from somebody else coming in and demanding that information, because they're saying, well, no, it's in our control. If we release that to you, we have interfered with Prince Harry's privacy rights. And they did argue on the it doesn't protect iniquity. So their argument was, well, no, we suspect he's lied about his application, or it shouldn't have been granted because he'd done something wrong. So that gets rid of the privacy aspect. But they couldn't get over the first hurdle, because it was like, well, you don't know that. You're only speculating. You are on a fishing expedition. So therefore, we're not going to breach the privacy just so you can see if you have a case or not, or a claim or not. So that's why I wasn't surprised. Although the flip side of that is, as a public body, susceptible to judicial review, are they exercising their powers properly? They have to explain the reason for their decision. So that's why they released as much material as they thought they could, but it's all redacted. But the idea is it shows the thought processes they did, which will minimise the chance of them being judicially reviewed. But yeah, I mean, different jurisdictions have different rules. It's like over here, you have no right to your own image. I mean, I'm stood here. If somebody walks in the background, well, tough, there's nothing they can do about it. If I was going to exploit this properly commercial, like in a movie, they will get people to sign waivers. But technically they don't have to. Whereas in France, for instance, you have a right to your own image. So, if somebody comes up and snaps a photograph of you in the street, you can say, well, no, stop that, delete that. France is really interesting about how much they protect property rights. A little bit trivia, because I know you like them. You cannot sell a photograph of the Eiffel Tower at night. You can take a picture of the Eiffel Tower during the day and sell the photograph because it's out of copyright. But the lighting rig is still in copyright. So if you sell it, you're exploiting the copyright. You can take a picture yourself and just use it. And they really do stamp down on this, just basically so you can only buy the official postcards. Also, if you notice on Google Street View in Paris, a lot of the buildings are pixelated because the design is still in copyright or still has IP protection. It's slightly different for whether it's a sculpture or a creation and all that. I'll have to do a thing about what attracts IP rights and what doesn't, because it's all just really interesting. It's like if you want to protect your design rights in a chair, you have to make it as unchair-like as possible. And there's a really interesting one where somebody tried to copyright a lamp, a lamp. And they said you can have IP protection in the base because that's all artistic and nice, but you can't have IP rights in the top of it because that's just like, you need a switch and a shade and stuff just to make it work as a lamp. That's a little aside. But it's sort of related. It's all about intellectual property, do your own image, and also private information. In fact, one of the first cases on intellectual property, it's a case called Oxford and Moss. Some Oxford undergraduates, well, the one guy got nailed for it, he snuck into his professor's office and he took away the exam paper and he just copied it. But then he put the paper back, actually. But could he be done for theft? Because he hadn't permanently deprived them of the paper by putting it back. So what had he actually stolen? And they said, well, you have stolen the information in the exam paper. And they said, well, that's not property. And they said, yes, it is. It's intellectual property. So that's how that first started. But again, it's all down to sort of privacy. If somebody is breaching your privacy, can you do anything about it? Can you get an injunction? Yes, you can. And injunctions in privacy, unlike in defamation, are relatively readily granted pending trial. Because if you think somebody's about to breach your privacy, you can run along and say, I want an injunction to stop them doing this. And the courts take the view that, well, we need to preserve the status quo. So at the moment, the information is private. We can decide at a trial down the line whether it needs to be. But in the interim, we will block that, because once the cat's out of the bag, you can't put it in again. Although the mere fact that the information is out in the public, that can actually, you can still get an injunction on that. There is one of these equitable maxims that equity will not act in vain. In other words, You can bring a common law lawsuit even if you get nothing out of it at the end, even if it's pointless, but you're just entitled to do that. Whereas equitable remedies, normally they'll only allow you to run them if you'll have a material benefit. But that is one exception where even if the information is out there, you can still get the injunction. And that all dates back to the spy capture case, where they said there's no point in injuncting it because people are just importing it and reading it anywhere. And the court said, well, no, because otherwise we're just encouraging people to defeat injunctions just by jumping the gun and slipping the information out there. Whereas in defamation, we have a doctrine of no prior restraint. Bonnard and Perryman is the case, which says, publish and be damned. So unless you can show that you would definitely win at trial on a defamation claim, which is actually quite hard because there's so many defences, then they won't make the injunction. However, you can get mix and match injunctions. So say, for instance, you say something is both a breach of privacy and defamatory. Like you employ a nanny, she's signed an NDA as part of her employment contract, but then she does a big tell-all story about how terrible you are to the children and how dysfunctional your family is. In that particular case, even though they said the information is false and therefore it's defamatory and wouldn't normally attract an injunction, they said also, no, because of the contractual arrangement there for privacy, we're going to say we'll give the injunction on the privacy thing. I mean, they did try and argue and said, well, no, this is to expose iniquity and wrongdoing, so that should defeat all that. But they said, well, this is only the injunction stage. We'll let this go to trial and we'll decide whether any of your stuff is true or not and whether or not you are in breach of privacy. So it all gets a bit complicated. But yeah, there you go. Like I say, I was not surprised by that decision. It'll be interesting, though, to see if this organisation, the Heritage Foundation, whether they judicially review the decision not to release the information. I suspect they will. And if they do, watch this space. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. I'm just back up at Pentire, stroke Pentier again, trying to get a decent shot. It's not too windy today. The sun's slightly in the wrong direction, but remember the last time I was up here, I had to sort of hang around up on the cliff. So what I'll do now is I'll try and pan around and just show you where actually that cliff was that I was hiding out in. So yeah, there you go. That's the cliff, and I was up there somewhere. But it's a lovely spot, and just to sort of show you around, because I wanted that island in the background. Well, that's quite pretty with the sun, isn't it? But people will probably recognise that island from all the videos I do on the other side. And now I can spin around because I've got the sun looking in the right direction, just so you can see me. Check, I haven't got spaghetti in my teeth. Sorry, spinach in my teeth like I did on the last one. And I'll see you next time.